Looks like the parties are ready. We're now here in the matter of State versus Lindaman. Mr. Taylor, you may begin.
Counsel. May it please the court. I am here today on behalf of Dr. Lindaman. He was convicted of sex abuse in the second degree in Polk County after a multi-day jury trial. We're asking this court to overturn that conviction and set this matter for a new trial. We have raised several issues that warrant reversal of the conviction. And most pertinent and the most clear violation involves Dr. Lindaman's right to confront his accuser, and that is HK. At trial, she was allowed to testify via closed-circuit television one way, meaning she was unable to see Dr. Lindaman during her testimony while he was separated physically, placed in the courtroom with the jury while HK was testifying in a conference room elsewhere at the courthouse.
Objected to that procedure, right?
Yes, Justice Oxley, we filed a motion to declare Iowa Code 915.38 unconstitutional, which is the code section that allows for the remote testimony. We also objected to remote testimony at the hearing when the state asked for that remedy. And at that hearing, we were allowed to cross-examine the state's witness, Amanda Rendolot. That was HK's therapist. And so error was preserved by asking for that statute to be declared unconstitutional and objecting.
At that time about using two-way versus one-way, or was it just objecting?
No discussion about using two-way. The request from the defense was purely to object to allowing HK to testify remotely.
You started off your conversation with, or your discussion with, one way was used, which means the defendant could see her, but she could not see him. Okay, if she was in the courtroom, are you saying that you can require her to physically look at him?
I don't believe confrontation requires to force someone to actually maintain eye contact or visual proximity.
But she couldn't look at him. That implies to me that she has to look at him.
To be clear, what confrontation requires is the structure of a trial to allow a witness to be in the same courtroom, to be in visual proximity of the defendant, and have the defendant be able to lay eyes on the witness and vice versa for the witness towards the defendant. That's what confrontation requires. And that's what we're requesting. There is not some sort of requirement that we have to force a person's head to maintain a certain direction of visual proximity. That's not the request. I think what we're talking about is what State v. White created and really emphasized is that Article 1, Section 10 of the Iowa Constitution, it is essentially the architecture of what a trial should look like. It is the procedure to ensure that we have truthful testimony and really put testimony to the test to ensure that truthfulness and to assure that justice is maintained. It creates the procedure. And I don't believe a confrontation requires an interjection from the court to determine whether testimony is reliable. Now, what I'm referring to is what Justice Scalia talked about in his opinions involving Crawford and his dissent in Iowa v. Coy. Procedure is the most important part when we're talking about confrontation.
I asked you a question about a different issue, which is the 80420 suppression issue. And I'm interested in, there's kind of a disconnect for me when a defendant who's in custody is given his Miranda warnings and told that any statements he makes can and will be used in evidence against him, and he signs the waiver and then objects to his statements being used in evidence against him. I guess I'm wondering why that warning, the issuance of that warning doesn't solve any concerns we have about the confession and why it shouldn't be used in evidence, even assuming there was an 80420 violation. I just want to assume there was for the purposes of this question.
in the Moorhead case, if that is the case I'm thinking of, the issue was, as it is the same in this case, is that the Miranda warning does not involve communications with family members. So I think that's issue number one. But 80420 is really your lifeline to the outside when you're in custody and gives a detainee the opportunity to be able to contact someone and perhaps discuss the issues at play, the Miranda warning that they're signing or the Miranda warning that they're receiving. So I believe that is why 80420, even with a Miranda warning, even with a signing of that waiver, that's why 80420 still requires exclusion of that evidence, because there's still a violation denying the detainee the ability to contact the outside world and discuss these issues.
I'm sorry, go ahead. Counsel, I'm a little curious about 80420 and how we ought to think about it. I mean, traditionally, in recent times at least, we certainly have had exclusion as a remedy. But the exclusionary rule is this really founded in policy, right? This idea of the policy benefits of excluding it. But in 80420, the legislature had already made a policy determination about a remedy for violations of 80420, namely a simple misdemeanor, I think, right? And so does that matter at all in our analysis or our thinking about it?
The rule is based upon the basic concept that if there's a violation of law, the party that wants to introduce evidence based on that violation should not be allowed to. I think it's the basic concept. And though the legislature did put a remedy in, it doesn't really cure the issue in this case, is that Lindaman was denied the ability to consult with someone outside the police station. And that's why it's important to have a remedy like this, because what the record does not have is any sort of detail or evidence that there was any consequences that the Ankeny Police Department faced for the violation of the rights. There's no...
It's a little more. This isn't a constitutional right that we're talking about, right? It's a statutory right, correct? Right? That the legislature put in place, and it came up with its own remedy for it. And so why should the court put in a different remedy when it's not a constitutional issue? It's a statutory issue.
Long-standing principle that dates back to close to the time when the Iowa Constitution was put in place, when Iowa became a state, that violation of law should not benefit the person that violates the law. That is the case law that we see from the 1800s, and though that principle was temporarily abandoned at the beginning of the 20th century, I think that is interwoven into the state of Iowa, that principle that you should not benefit from a violation of law. And so that's why 80420 and violating a statutory principle, even though it's not a constitutional right, and it still has an important part to protect people that are detained by law enforcement and ensure that that right's being given to them. Because I think we don't have a record here, but I don't think it's going too far on a limb that simple misdemeanor is not going to protect detainees in these situations. A simple misdemeanor is not going to discourage law enforcement, considering just the reality of the situation that a proceeding like this involves likely a county attorney that consistently works with law enforcement. And if these issues are going to arise, they're not going to go after their own witnesses that they deal with on a consistent basis when bringing charges and bringing prosecutions. And
The legislature would have been aware of and able to factor in.
I mean, the legislature, again, did put that remedy in the 80420 statute, but I do believe that Iowa still has a principle that the state, as an actor, should not benefit from a violation of law.
Have we held that exclusion is the remedy for an 80420 violation?
Beater was late 70s decision, so we've had it for getting close to 30, my math is correct on that, 30 years. If I was good at math, I'd be a doctor.
I thought that was not the right remedy. They could have amended the statute to fix that. So we've got legislative acquiescence here.
That statement, we've had 30 years now where it's been very well known that a violation of 80420 rights leads to exclusion, especially in OWI cases. We've had numerous cases over the years.
Go ahead.
Can you address the state's argument that there's not really a causal connection between the request to call Mr. Lindaman's wife to cancel an appointment and his subsequent statements?
And first, Justice Oxley, just respectfully, I'd push back. I don't believe the record establishes that the purpose of the phone call was to cancel an appointment. I think the record, looking at the exhibit and based on the district court's ruling, was that these were two separate requests. The request to call his wife was separate from the request to cancel a haircut. Now, the issue with a violation like this is we don't really know exactly what happens because of the violation. So there's not gonna be a record that establishes that Dr. Lindaman's purpose for the phone call was to talk to his wife about the charges, to talk about what he should do, maybe get a hold of a lawyer, because again, at the beginning of his interaction with the Ankeny Police Department, he did ask to speak to a lawyer at the beginning. And so the casual connection is the violation happened, prejudice has to be presumed because there's really no other way to establish what could have happened, because you have to completely deal with hypotheticals. But we know 80420 protects a very vital interest of a detainee to ensure that they can reach the outside world.
Violation happened. At what point did it happen?
When detective was asked clearly, I want to call my wife, and they had possession of the cellular phone of Lindaman, and that phone was not provided, and there was no active effort on behalf of the police department by anybody to ensure that phone call was made.
At discussing this issue of exclusion and the violation of the statutory right, what language in the statute indicates that there's an affirmative duty by the police officers to do anything more than have a phone available? I mean, obviously they can't physically restrain him. They can't do anything like that. The statute just says permit, and through a series of cases, we've kind of put this judicial gloss on it that now there's, an affirmative duty to kind of facilitate the call. But if we're going to talk about violations of the statutory text, I guess what provision of the statute do you think is violated?
Which clearly indicates that there has to be a permission of allowing the phone call to happen. And what State v. Hicks and its progeny discusses is that in reality, in order to actually allow this right to exist, law enforcement have to take steps because of the power imbalance that exists in a lot of these situations when someone is arrested, and exist clearly in this case where you just have a police officer in a position of authority while someone is clearly arrested, been handcuffed, taken to a police station against their will, that when that request gets made, there has to be some affirmative steps by law enforcement to ensure that right is exercised.
It's a simple misdemeanor offense to violate the statute, right? So if you were, let's say an officer was charged with this offense and you crafted some jury instructions based on the language of the statute, could you convict an officer for failing to affirmatively facilitate a phone call for the defendant based on the language of this statute?
Permitting, I still believe, impose an affirmative duty on law enforcement that take a step to allow this to happen. That you can't just sit there like State v. Hicks case is, because that's a clear indication why, if you don't have this requirement for law enforcement to take affirmative steps, the right completely disappears. You had someone that made the request, they gave kind of an answer saying, yes, you can make the phone call, but not do anything to allow that phone call to happen, and because of that power imbalance, the defendant in Hicks was denied that right.
You brought up the particular circumstances of this situation. Should we take into consideration Dr. Lindaman's sophistication or the fact that he's sitting on a couch right next to a phone? Don't those things sort of suggest that he was permitted to make a phone call if he wanted to?
Because that type of analysis goes to more of a knowingly waiving a right or waiving the ability to do something, and that's not part of the analysis. And that's why essentially the burden rests with the police officer in that situation to make sure that phone call happens when the request is made, to do something besides just stand there, remain silent. And I guess to put I have 8 seconds here, to put a point on this, let's be clear with the record, what it says here in this case. The request was made, and there was just essentially a denial. And the statute requires without, any sort of reasonable delay. And that phone call was delayed. So
We're going to be coming back, but two-way video versus one-way. We left the question open in white. Would it be unfair to the parties to leave the question open again, or should we say definitively whether two-way video would satisfy the confrontation clause?
as someone who will probably litigate this case again, I would like to have some clarification from the court, because this issue will be brought up if this case does return back to district court to discuss this issue of what is the appropriate procedure to allow this testimony to happen.
Two-way ameliorate the right to confront? Does it cure the violation?
My position is no. That has to be in-person testimony, face-to-face. With that, I yield my time.
Thank you, Madam Chief Justice, and may it please the court, counsel. Good afternoon. It's a privilege to be here again. White should be overturned. The Constitution does not require the result. Article 1, Section 10, correctly understood, requires confrontation, but does not include the express face-to-face requirement that some other states do. I actually went back to the constitutional conventions in preparing for this case, and on page 736, Mr. Harris, I believe Harris, it might be Hall, in objecting, confirms that he's reviewed all of the similar provisions, similar to Article 1, Section 10, in all of the other states' constitutions that exist in formulating his challenge to the other cases involving life or liberty. I just mentioned this to make sure the court knows that the framers of the Iowa Constitution were aware of other provisions that included other language, and they still chose not to include a face-to-face requirement. In other cases, this court has found that to be the disinclusion of certain language to be compelling and relevant. It should here. It wasn't in White, and it should have been.
Clarify that a little bit. So it's your position that face-to-face is not a constitutional right. It's confrontation. Is that correct?
So my understanding, and I think this is consistent with Brown, the 1911 case, also not mentioned in White, but it should have been. Brown surveys the authority in the area and the precedent and says the essential kernel of confrontation is an opportunity for effective cross-examination. It is preferable to have face-to-face. And in most instances where
And required.
instances where it's not possible or there are other barriers to it.
To avoid face-to-face confrontation if it's not a constitutional right.
It is constitutionally preferable. There's a right. It means that it can be overcome with a showing of both some amount of necessity for not granting it in that case, and a showing of some assurance, procedural or mechanism for the defendant to examine the evidence, examine the testimony, or assure its reliability in some other way. Now, if you look at Green and Justice Harlan's dissent or concurrence.
I mean, frequently we talk about a right, and nobody's going to dispute that rights can be infringed or restricted upon a certain justification. But that seems to be not the argument you're making. You're saying it's just not a right at all. I mean, it seems like it would be better to say, I get it, the Supreme Court says constitutional preference. That's fine. That's their language. We used it in Rogerson. But what does that mean? Either it's a right or it's not, and then we can argue about what's a sufficient justification to overcome the right. But if you're saying it's just not included at all, I don't know why the state needs any justification.
What I mean is that it's basically presumptively applicable but displaceable by a public policy interest, usually embodied in an existing common law exception, but that public policy interest new ones can emerge when there is the showing of those two components, necessity and a procedure for examining or otherwise ensuring reliability. I mean, if you want to look at it, we all know that Article 1, Section 10 was never absolute in its application across the board. It always included an exception for dying declarations, which are never cross-examined to any degree. This court in White referenced both Collins and Rydell. If you want to go to exactly the words that were used in those cases, yes, they use the phrase face-to-face, but only in this, when they describe what that means, they say, the witness giving testimony where the defendant can see them, is what they specifically say. Now, you might say, okay, but they weren't parsing the issue. They weren't dealing with the issue of testimony given where the defendant can see the witness and the witness can't see defendant. And to that I say, exactly. They weren't dealing with the issue raised in this case. They weren't deciding whether that is sufficient to vindicate the confrontation right. The other thing I'd say about those cases is that Brown also could have and should have talked about Kimes, Fitzgerald, and I already mentioned Brown. In Kimes and Fitzgerald, prior testimony, deposition testimony in one and preliminary examination testimony in another, comes in at trial, even though that witness is either unavailable or deceased. I think at Brown they were unavailable because they were in another state that was far away. And the court says that doesn't violate the confrontation clause, even though the evidence comes in, the victim's not physically present at trial, the prior opportunity for cross-examination satisfies the confrontation right. And that's why I brought up Justice Harlan's concurrence in Green, because I listened again to the argument in White, and I was mystified by the reference that Professor Wigmore has fallen out of favor or misinterpreted cases. And I don't think that criticism is correct, but I do think that Justice Harlan's concurrence in Green identifies that when you look at both old federal cases and Iowa cases, the common thread running through them is in-person testimony, which necessarily would have been face-to-face then, preferable and required when the witness is available. And if the witness is not available to give that testimony, then you need both a showing of necessity for that testimony and that it has probative value and wouldn't really be obtainable another way, and that the defendant had an opportunity to cross-examine it or some other guarantee of reliability. That's dying declarations in that camp.
Presumption of innocence play in this determination?
So the presumption of innocence means that the court isn't deciding the truth or falsity of the victim witness's allegations of sexual abuse. The victim may incorrectly believe that they were abused. The only question is there evidence that the victim would experience trauma that would render them unable to communicate effectively or testify in a way that would provide the evidence that is going to be probative? And only with that showing is the statute satisfied. Only then can the one-way CCTV testimony be presented. If White's talking about a truth-telling function, confrontation clause guaranteeing a truth-seeking effect, that is actually undermined by requiring a victim witness where that showing's made. It's undermined by saying that they can't testify by CCTV, because the finding has been made that their testimony will not effectively describe the events. They won't give the evidence effectively. It won't actually come in. The jury won't hear what happened.
Accommodate potential false testimony to make it easier. I mean, it seems to me the finding is implicit that this witness was abused by this defendant, and because of that, this witness will be traumatized by seeing the defendant. I guess maybe I've missed it, but I haven't seen in a lot of case law false trauma based on misperceived, allegations of abuse. And if I've missed that, I apologize. But it seems to me the basis for all of this is that there's a finding by the court that this defendant did it, that this witness shouldn't face it. And so in this category of cases, these defendants get a different kind of trial than other defendants.
So it's explainable because, first off, the requirement of inflicting trauma means that it's not being granted just on the basis of the court isn't making a finding on truth or falsity.
Finding that being in the presence of the defendant would inflict trauma on the witness without implicit in that finding being that the abuse occurred?
Because it doesn't rule out the possibility that the victim believes the abuse occurred and is incorrect, or some amount of the events after and the relationship has created a situation, right? And the court doesn't have to weigh, and also the court doesn't really comment on the veracity of the witness's or even signal to the jury that it believes that the witness is particularly believable. The jury can just be told that the witness is testifying remotely because they are a child. They are.
Get to, it's pretty obvious when a child takes a stand, it's a kid. It's a kid, so I think there's already a different perspective. If this court were not to go along with reversing White, and by the way, you don't need to persuade me, see dissent, but if we were not, what do you think about, is this the opportunity, should we be talking about, is two-way okay? And I asked your opposing counsel, do you think the kid has to physically look at defendant? I mean, we need to talk about, how about two-way? Are you okay with addressing that?
I believe two-way video should be permissible, but the reasons I'm going to give you are the same reasons I think one-way video testimony should be permissible. I've never, in the cases I've read, even Collins and Rydell, they don't talk about confrontation as requiring the witness to look at the defendant. If anything, it's the defendant to view the witness, the jury and the judge to view the witness. But two-way video, at least, if you think that there's a problem with the witness not viewing the defendant, two-way would satisfy that, while still assuring the victim witness of their physical safety. The interesting thing, I mean, I've always had this question lurking in my mind is, can a blind victim even testify under White? And I'm not sure what the answer to that is, because if you're saying that, anyway, that's lurking out there. Also, telling the child witness, just the defendant's over there, but you don't have to look at them if you don't want to. It's not really effective at, first off, children have very bad impulse control. The fear response can take over. I pointed the court to some evidence that the trauma response inhibits the areas of the brain that are responsible for speech and cognitive processing.
Discussion we had a minute ago, I'm trying to process this. So you're saying there's no implicit finding that the defendant abused the child witness, correct? And that it, not necessarily, because it could be a false belief by the child that this was the abuser. So your answer is that we should run a trial based on the premise that we should facilitate potentially the false testimony of a person who's wrongly accusing a defendant to make sure that they can falsely testify in a more convincing fashion.
Is twofold. First, the trauma requirement will get rid of a lot of the false accusations, because most of the time those aren't going to produce trauma. But to the extent that you're concerned that false testimony is going to come in, the jury is responsible still for deciding whether they believe the witness's testimony. And there was meaningful and effective cross-examination here, as there is in one-way CCTV cases. HK was cross-examined by Lindaman's agent face-to-face. This examination happened in full view of the jury. And this is after a deposition where the same thing happened. There's no way to look at what happened in this case and say this wasn't a opportunity for meaningful and effective adversarial testing of HK's testimony. You can't look at this and say the jury didn't really do their job of deciding whether they believed HK. And the closing arguments make this clear, that the parties are not without ammunition to argue that issue. HK's believability and the credibility of her testimony was arguably the focus of the trial, and the fact that it was taken by one-way CCTV doesn't appear to have materially impacted that in any way.
About 804, well, are you second? All right. On 80420, why is exclusion the proper remedy here?
I don't think it is, because I don't think that the, if there is a violation, and I don't think there is, and I can tell you why, it's not causally connected to the detailed voluntary confession after a Miranda waiver. That this is an instance where if there was a violation, it was kind of, it was a technical violation, and Mr. Lindaman showed that he was uninterested in making phone calls at all. He just wanted his phone.
Exclusion at all of this evidence?
I think that this, I mean, no, you're right, that the statute specifies the remedy. I don't think this court needs to go that far, and that could have implications in OWI cases, but I definitely think that at least when there is a voluntary Miranda waiver, definitely exclusion is, and that was suggested by this court in Bowers, where they said, this court said, if you have a violation of 80420, but a voluntary Miranda waiver, we're very hesitant to exclude the resulting statements.
What we've also said about 80420 also allows you to call a family member. And we don't know what would have happened if he would have called his wife. She might very well have said, don't open your mouth. Let me, I'll call the attorney, something, but we don't know what that is. And that's kind of why we've excluded it in the past. So how do we know that there's no causal connection?
Two answers here. One, his wife testified that she never spoke to him again after he told her what he did that night. Two, when left alone in the room with the phone book and the phone, and he knew that both were there, he didn't call his wife. When he was permitted, that's the language of the statute, thank you, to make the phone call, and he was permitted the whole time because he could have invoked Miranda, but that whole time with nothing to do, he did not call his wife or make a call to cancel his haircut, which I still think are the same call, but even if you think they're both.
He testified for a while, or talked to the officers for a while. Had he given some pretty damning discussions by that point when he was left alone?
He had made statements, the same statements that he had made to his wife and to HK's parents, which, I'm sorry, I see my time's expired, if you don't mind. Thank you. Which he seemed to think were, an explanation. Now, at this point, I will concede to you that we are both talking about a counterfactual scenario that didn't happen. But the question is, you just need to apply your reasonable judgment here and say, well, he wasn't interested in making a phone call then. He also wasn't interested in making a phone call when the phone was pointed out to him. Now, the trial court says that the camera establishes that he was looking right at the agent who made the gesture towards the phone, which I believe came from Exhibit 4, like the overhead video, and the court says, but he didn't look back at the phone to make sure that to see what the agent was pointing at. Well, yeah, he had just stared straight at it while his cuffs were being undone. He knew the phone was there, and he looked straight at her because he was unconcerned about the phone. He didn't want to place a call. He wanted his phone back. He got the answer he wanted, and then he voluntarily waives Miranda. He's told that he can stop the questioning at any time to call, and that he can call a lawyer. And he doesn't choose to. We know the decision that he made. He was advised of, even if you think the advisory was technically deficient, and I've laid out the reasons why I don't think it was, we know from the facts that we have that, pointing more directly to the phone or saying, look over here, turn your head, would not have resulted in him doing anything different. And we know that from the decision he made not to invoke Miranda and from the decision he made afterwards just not to use the phone at all to make any kind of call.
Decision previously, and Mr. Taylor says, well, post Bowers and I think it's Moorhead, the court considers that and rejects it as a reason for not excluding the evidence. So how do you deal with the tension between those two cases? Because it does seem like Moorhead has already talked about this post-Miranda confession issue.
Yeah, one is that Moorhead is an OWI case that dealt with the time pressures involved in OWI investigations, and the other is that in Moorhead there was no advisory that, like, yes, you can place a phone call. It was just Miranda standing alone, and standing alone, they said that didn't cover the totality of 80420 rights. And if this court is going to reconsider exclusion as a remedy for a violation of 80420, that calls Moorhead into question too. I also think that there's no issue about the causal connection between the statement, or between the lack of the advisory in Moorhead and the statements that were made in that case, where in this case, the evidence is pretty clear to establish a lack of that causal connection. That suppressing these statements, these voluntary statements made, with full understanding of what he was saying in clinical detail, that to suppress those on the basis of this, if a violation de minimis, would be to grant him a windfall and would be to keep out evidence that is a public good to have it admitted and available at trial.
I want us to overrule White. I was one of the dissenters with Justice Mansfield and Chief Justice Christensen. Short of that, how important is it that our court answer the question whether two-way video is constitutional? A question left open in white by the majority.
I mean, I would like an answer. I don't think that any prosecutor or district court judge is going to gamble on two-way CCTV until this court makes its position clear, because we're going to try these cases a fourth time. But I mean, I do think that this court, I don't know how you could write an opinion, which I think would be correct, that would say that two-way CCTV testimony is permissible without really re-examining and reaching. It would be tough to square with white, and understandably so. Okay, thank you.
And we're back to you, Mr. Taylor.
Thank you, Chief Justice. Picking up on the 804.20 issue, I think the issue with what the state is trying to advocate for here is it just involves a lot of speculation in terms of what happens when a right is denied. I mean, the record is not clear. We know that there is no phone call to the wife afterwards, but we don't know the reasoning or the mindset or why a phone call is not made. That is just not in the record, and that's not anything that's been established. That is all purely speculation. And to bounce around a little bit and going back to the confrontation issue, I think there's a lot of emphasis that's placed on where eyes are placed and who's watching whom. I think a part of confrontation is pomp and circumstance. It's the idea that you have a trial, that you have the seal of Iowa, you have a jury, you have a formal setting as a courtroom, and that you're placing a witness on the stand that the jury can watch and observe and have that witness present in the same room as the defendant. That also is part of that right to trial, the pomp and circumstance, the idea that someone is placed under oath and that what they have to say, the weight of being placed under the penalty of perjury, swearing to tell the truth, that is made clear by that procedure. And when you take a certain class of witness, treat them differently, take them out of that context, that has obviously some major implications in what the jury's minds and how they view that type of procedure. It's very possible that they look at something like that and determine that, well, I guess that witness does need protecting because they're being taken out of that context, they're being protected from the defendant.
Agree with everything you just said about I think you called it the architecture of the trial process, and it's aimed toward truth-seeking. At least our founders believe that this is the best way to get at finding truth. I find that interrelated, though, with this 804.20 issue. And if the purpose of the trial is to find the truth, and we have relevant and reliable evidence, I don't think there's any contention that this is a coerced confession or an involuntary confession. It's made after the full administration of Miranda warnings. Why would the exclusion of relevant and reliable evidence be permitted or even preferable if the whole point of this exercise is to have the most reliable truth-seeking process? Those don't square with me.
I think that's a very interesting comparison because I think it touches on the same issue. It's not about ensuring reliable evidence. That's not what confrontation's about. That's what Justice Scalia says. It's not about ensuring reliable evidence. It's creating a procedure to ensure that the evidence is reliable. The difference is it's the focus on procedure. The procedure in 804.20 says you have to permit detainee to make a phone call. This court has interpreted permit to mean affirmative steps taken to essentially invite that detainee to make the phone call. It is about the procedure, not necessarily the reliability of evidence. And so just like as the state keeps hammering in their argument that there is this unfortunate circumstance where a victim of sexual abuse may experience trauma, and that evidence and that trauma may be exacerbated by the trial process, here we have evidence that's going to be excluded because it runs afoul of that procedure, and the procedure is the important part, not the reliability. So I think that is an interesting comparison, and that's why 804.20, that's why the exclusionary rule is essential, because 804.20, again, it's protection of a detainee. It's that one phone call. It's your lifeline to get outside the walls of a jail or police station and seek outside guidance. That's why 80420 requires exclusionary rule, because if we lose that ability and the state is not essentially punished, we just kind of leave it to this idea that county attorneys are going to prosecute their own witnesses for simple misdemeanors, that right's going to evaporate.
Did you read our 80420 case from last term called Clark? Have you seen that?
You have to remind me of the facts of that case, Justice.
With a woman who had her cell phone next to her. And if you haven't read it, that's fine.
Remember this case, yes.
How that case plays into what we're talking about here in the 80420 question.
Really emphasizing the importance that the phone call is required when you are placed at the actual location of the police station or the place of detention, and not on the right page on that, because I think, again, what I keep saying over and over again is that it's that lifeline outside the police station where you're taken out of the environment that you were once in, the freedom that you have to be among the community, and you're taken into the blank white walls of a police station with that one shining light on you. That's why the phone call becomes absolutely essential, is when you enter that place of detention, and that would square completely with the Clark case. To change topics, part of the request that the defense is, or the appellant's making here today, is to dismiss the cross appeal by the state. In the brief, admittedly, probably not clear on the issue with the Rutherford case. And I think the state's cross appeal should be dismissed. It's not necessarily a jurisdictional issue. It is all about that the authority of this court to hear the state's cross appeal is derived from Iowa code. And the code makes it clear that, I apologize, I see I ran out of my time.
It's a really deceiving clock. Go ahead and finish your thought.
And the ability of the state to appeal a case is derived from the code. It codified some common law principles, but the code makes it clear that the state is limited to appeal a suppression ruling through the vehicle of discretionary review, which has to be filed within 30 days of the ruling being issued, which there is an extension of 30 days if they ask for it, but the state missed that deadline by almost 2 months, and there's no more avenue for them to appeal that decision, and that's where the authority comes from. So the authority is the issue, not necessarily the jurisdiction. And with that, I have nothing further. I would just ask the court to overturn the conviction on behalf of Lynn Lindaman and dismiss the state's cross appeal. Thank you.
Lindaman is hereby submitted, and court is adjourned.